2014-139, State of Arkansas versus Kevin Taggart. Court is making the appointment of the Public Defender's Office to represent Mr. Taggart. Mr. Taggart's for arraignment on charges of theft of property, Class B felony, and theft of property, Class A misdemeanor. On
Your Honor.
those charges, how does Mr. Taggart now plead?
Your Honor, he pleads not guilty.
Court will set Mr. Taggart down for reappearance in front of Judge Putman on June 26th.
Nothing further on this gentleman today, Your Honor.
You may be excused. 2014-141, State of Arkansas versus Mitchell Tecumseh. Court is making the appointment of the Public Defender's Office to represent Mr. Tecumseh. For arraignment on charges of breaking or entering a Class D felony, 2 counts, and theft of property, Class C felony.
Your Honor, to all of those charges, the defendant enters a plea of not guilty.
All right. Plea of not guilty is noted. I'm setting him down once again to reappear in front of Judge Putman on June 26th.
Your Honor, bond is not an issue in this case. I've been told that the court signed a probation violation order on him this morning by Mr. Nucio.
I believe it did. All right. Defendant may be excused then. Reappear in front of Judge Putman on the 26th. 2014-142, State of Arkansas versus Justin Jansen. It's for arraignment on possession of controlled substance with intent to deliver marijuana, Class C felony, illegal use of communication device, Class C felony, and delivery of controlled substance marijuana, Class D felony, 2 counts. On those charges, how does Mr. Jansen plead?
Not guilty, Judge.
Mr. Jansen's on this court's docket. He'll be set for trial December 1st and 2nd. Pre-trial will be October 23rd, and reappearance will be September 25th. There'll be a written scheduling order with all those dates. Anything else on Mr. Jansen's behalf?
Just one moment, Your Honor.
All right.
Your Honor, this might be a case we can dispose of this afternoon if he could be brought back at 1:30.
All right, put it in the stack. 2014-145, State of Arkansas versus Joseph Waugh. Waugh is for arraignment on charges of possession of controlled substance, methamphetamine, a Class D felony, possession of drug paraphernalia, Class D felony, introduction of a controlled substance into the body of another, a Class B felony, driving while intoxicated, Class A misdemeanor. I believe it's an unclassed misdemeanor. No driver's license or license expired, separate unclassed misdemeanor.
What's it, Coach's name?
Coach Barnhill. Coach Barnhill.
Your Honor, I represent Mr. Wall. We want to enter a plea of not guilty. We waive formal reading of the information. He does not have a bond yet. I want to address the court briefly. This is a young man that I brought before you once before on previous charges that are still pending. I told you then that I believed in him and thought that he was worth an attempt to rehab. You made a specific order that he was going to be sent to rehab, and if he left rehab for any reason until it was completed, or when it was completed, that he was to report back to jail. He went to the OMART program. He fooled me. He was not ready to turn around his life, and he left that program after an altercation down there. He says, at that time at least, for fear that he was going to get beaten up, but he did not report himself to jail. He went home instead, and he didn't stay there. He has now acknowledged to me that that's baloney. He walked away because he wanted to. You then agreed, and with very serious admonition to him, told him that he could go to a rehab program in Branson. The prosecutor, the last thing he said to him was, if you're not in that facility, you'll be in jail. He did it again. So he's got 2 strikes against him. Now, I've been doing this for 40 years, and I've been fooled by some of the best of them. I'm kind of tainted when looking at people like this who tell me they've met Jesus and they've changed their life. But this time, I actually believe him. For the first time since I've talked to this young man, he has taken responsibility for what he's done. It's always been someone else's fault. It's always been, his problems or his lifestyle or whatever. I believe that he has made a change. What he is requesting is that he be allowed to go back to the program in Branson. I think he's earnest in his desire to actually get himself cleaned up. I don't mean to be disrespectful, but I think the thing he said summed it up the best for me was when I asked him, what do I say to Judge Webb that makes him believe you this time, since you basically just conned us? And he said, I had my head up my bottom, and when I finally got it out, I liked the way the air smelled. He said, I want to be free of these drugs. That's probably the most succinct way I've ever had a person put that. But he has Coach Barnhill here with him today, some other people who want to address you, whether you want to do it in chambers or not. What we're asking is that he be given an ankle monitor so that we don't have a problem, that he won't be going anywhere. He needs help, and I think he is salvageable, and I think that he's worth another risk. He cannot get back in the program in Branson until he has been out of the program for 30 consecutive days. That will be up in 11 more days. What we're asking is that he be allowed to go back to rehab, to wear an ankle monitor when he completes it, whatever is necessary, to reappear here if you desire, to establish a bond. But I think he does have the desire for the first time to really succeed. He's got some good support from his family. He has basically been a terror in his own household. He has not cooperated. He's been living the drug lifestyle, and it has affected everyone. But they recognize the same thing I do, is that he's salvageable, he's worth the risk, he's never physically hurt someone else. Yes, he had a little girl that brought the methamphetamine, brought the needles, and couldn't inject herself. She supplied him with the dope, and he helped her inject. So there are things in his life that are not good, but I think that he's worth another try.
Your Honor, this young man is a young man that's court that the state have tried to help from time to time. The problem is he's got a drug problem. And, if he gets out of jail today, I'll think he'll be back on drugs.
Well, I'll say right now, the court doesn't have any intention of just letting him out of jail.
And if he can get into a rehab program and stay, he's tried twice and failed. The problem, if it goes to Missouri, he may be a little bit difficult to get back, but I guess we can deal with that. But if there's a rehab program we can get into, I'd just suggest to the court that we wait until his 30 days is up and then bring back some proposals for the court to consider. Because I certainly am not going to oppose him going to rehab, but again, he's tried twice and failed, and at some point he's got to understand we're just going to quit spending resources on him and move on to somebody else.
Your Honor, I usually don't do this, but if the court will permit it, I would like him to address the court. We're not planning anything, and let him explain to you the difference, if the court would allow it.
I think it'd be better done in writing, Your Honor, so we can see what program he actually intends to get into.
He has written me a letter. I guess he actually addressed it to the court, if I just may present that to the court.
The court has read and will consider the written statement, but it does not set out what Mr. Kincaid is suggesting, and I think is essentially what we need. Is we need a specific program for him to complete. One of this court's problems is just so that we're all understanding where I am on it, is that Mr. Waugh is on the Division III docket. He's not his case for criminal disposition is not on my docket. It's on Judge Putnam's docket. And so technically, I guess I need to set him down to reappear on the. Did you say I have another case pending on?
Judge, you have two on your docket, one on Judge Putnam's docket. just the way of the draw. It's,
Could we agree to consolidate them here?
Well, why don't we, the court will, if it's agreeable, the court will transfer this case to the Division 4 docket.
probably it's 2013 340, 2014 10 are the two that's already on Judge Webb's docket.
And we'll make an order transferring this case to the Division 2014-145 to the Division 4 docket. At this point, based on his past behavior, I'm not going to authorize his release, subject to looking at, I'd like to have the specifics of a program that he's going to get into. I would prefer that it be a program in the state of Arkansas, simply because jurisdictionally I don't have a lot of authority in the state of Missouri. That's the problem with that. It will have to be, I will authorize his, I'm willing to authorize his release on bond, subject to returning to jail when he completes the program. We have the HRA program that's in that health resources, whatever that is. It's the old Wilbur Mills program down at Searcy. Is probably the most local program we have. Omar has already been unsuccessful in his case, and they're having funding issues. So I'm not sure that's a program that we can count on anymore. You know, there are excellent programs over in the Fayetteville, Benton County area that through Decision Point over there, and I'm not sure that HRA isn't trying to consolidate those into their whatever they're doing these days. But I think he needs an inpatient treatment program, and I will authorize his release to a program, but I need a specific written one. And at this time, subject to receiving a recommendation from that, I'm not going to authorize his release until we have a specific program to put him into. In any case, he's got to, and he can start working on that. If he's not going back to Branson, then he doesn't have this 30-day limitation. But you know, if you want to propose the Branson program and can convince me that's the best program for him to go to, I will consider it. But my real request would be that we look at something in the state of Arkansas where the court has more jurisdictional control.
Your Honor, Coach Barnhill has come here to address you. Is it possible he could do that, or could we do it at a break in chambers, or?
The problem is the length of the docket today. I don't think I'm going to have a break here.
Correct.
So
Okay.
we'll, you know, I'm willing to work with him in terms of, I mean, I think I've seen enough of him, and I've seen enough of other people in a similar situation to understand that this is a person who really does need treatment, and ultimately maybe he mentions in his letter that his desire to get in the drug court program, and that may be the place he needs to be. But rather than release him on bond at this point to just go out and continue using, if he's truly an addict at this point, and you know, that's about the worst thing we can do for him. And so the court's position is that if we can get him out of jail into a solid treatment program, the court's willing to do that. But we need to have a specific program and plan, and then we can put together a specific conditions of his release. Failing that, if we're just going to go down the road toward trial, etc., court will set a bond, and we'll take that approach. But what you've asked for is a treatment approach to bond, and the court's willing to do that. But I just need a specific program at this time.
All right, thank you.
All right. So until then, he'll remain incarcerated.